In Texas, juveniles who commit criminal offenses processed by the juvenile court of the appropriate jurisdiction under the Juvenile Justice Code, and juveniles are considered 17 and younger. However, on petition of a prosecuting attorney, if a juvenile has committed certain offenses under the penal code, the juvenile court may waive its exclusive original jurisdiction and allow the child to be tried as an adult in criminal court. This area of law is governed by the Texas Family Code Section 54.02, and there are several steps in the process before a juvenile may be transferred to criminal court to be tried as an adult. 1. The offense that the child is alleged to have committed must be a felony. If the child was 14 years old at the time of the alleged offense, the offense must have been no less than a first-degree felony. If the child was at least 15 years old when the alleged offense was committed, any felony will do. Children under 14 years of age may not be transferred to criminal court until they reach the age of 18, and if several other provisions are met. The juvenile court must conduct a full investigation and a hearing to determine whether probable cause exists to believe that the child committed the offense alleged. Probable cause consists of sufficient facts and circumstances to warrant a prudent person to believe that the juvenile committed the offense. The court must also determine, based on the seriousness of the offense alleged or the background of the child, whether the welfare of the community requires criminal proceedings. Prior to the hearing, the juvenile court must obtain a complete diagnostic study, social evaluation, and full investigation of the child, his circumstances, and the circumstances of the alleged offense. This study and any other written material to be considered by the court in making its transfer decision must be provided to the attorney of the child at least 5 days before the hearing. If the court decides to transfer the case to criminal court, this material will also be provided to the prosecuting attorney for the state, but it is an inadmissible evidence. During the hearing, the court can consider just about anything: hearsay statements, written assertions, oral testimony, police reports, anything that will help the court in considering the following 4 factors: whether the alleged offense was against person or property, more likely to be transferred if the offense is against the person; the sophistication and maturity of the child, the record and previous history of the child, and whether the child can be rehabilitated and the public adequately protected if the court does not transfer the case and rather uses only those procedures, services, and facilities currently available to juvenile offenders. If after receiving all of the information stated above, the juvenile court decides to waive its jurisdiction, it must state in the transfer order specifically its reasons for the waiver and transfer. The decision of the juvenile court to transfer a case to criminal court cannot be immediately appealed, as it is a criminal matter. Under Article 44.47, the Texas Code of Criminal Procedure, a challenge to the certification and transfer order can be made only in conjunction with the appeal of conviction or of an order deferred adjudication for the offense for which the child, now adult, was transferred to criminal court. Types of juvenile waiver include waiver, remand, bindover, and certification to criminal court. Since the early days of juvenile court, state legislatures have given juvenile court judges statutory authority to transfer certain juvenile offenders to criminal court. In some jurisdictions, transfer is called waiver, remand, bindover, certifications. These occur when youths meet certain age, offense, and in some jurisdiction, prior record criteria. The judicial waiver process varies from state to state, but at the typical waiver hearing, probable cause must be shown. In addition, in many states, the prosecutor must show that the youth presents a threat to the community, existing juvenile treatment programs would not be appropriate, and programs within the adult system would be more appropriate. A juvenile does not have to be a repeat offender to be waived to adult court. In Texas, the minimum age is 14 for a first-degree felony, 15 second to third-degree felony, or state jail felony, capital felony, aggravated controlled substance felony. It is once an adult, always an adult. So if you are, as a juvenile, charged as an adult, then if you repeat again, then you will again be charged as an adult. I personally feel a juvenile should not be committed as an adult. I believe that juveniles are not fully developed mentally and emotionally to stand trial in criminal court. I do believe that more psychiatric treatment should be done for juvenile offenders. I believe that once a juvenile has completed their sentencing, that they need to remain in some form of therapy to watch for personality disorders that trigger criminal behavior. But I ultimately disagree with juveniles being tried as an adult.